right, let's do a little dog toy.
This case is so
This
funny.
case was argued last week, and there's just a lot of reasons that we're going to talk about this case. And that, frankly, the decision, it's one of the few times where the decision is going to be less interesting than the facts of the case and the argument of the case. So, you're all familiar with Jack Daniels and what a Jack Daniels bottle looks like. And it's like a, black label. The font is very specific. It says Old Number 7, Tennessee Sour Mash Whiskey, all of that, all right? There is a company that has made VIP products that has made a Bad Spaniels. Get it? Jack Daniels, Bad Spaniels. It's a dog toy. It also has a black label. The font is the same, and it says the Old Number 2 on your Tennessee carpet. Get it? All right. So
that's some quality humor right there.
Jack Daniels sues VIP for trademark infringement and dilution. We're not going to get too far into the weeds on this. Maybe the decision will be really interesting. But David, I did think you would be interested on the legal side of something that we've skimmed in and out of on this podcast, which is the relationship between trademark infringement and the First Amendment, and specifically parody. So in this case, they're arguing that this is really protected because it's a parody. Now, this case does deal with some First Amendment, but actually it's really in the weeds of trademark law and a lot of precedent. So we're not going to get into a ton of that here. But it led to a fun oral argument in a number of ways, David. And I wanted to talk about that because sometimes I point out, like, hey, if you're ever looking to beef up your oral argument skills, go listen to this oral argument and learn from the best of the best. So Lisa Blatt, who is certainly the most, decorated female advocate at the court at this point, but really among the most decorated advocates at the court, setting aside gender. And I would argue in the top 5 most famous advocates at the court. She argued the angry cheerleader case. She appears at the court multiple times a year. But she's got a certain style, David. And I'm just going to say, if you're a young lawyer or law student who wants to beef up on their oral argument skills, do not try to imitate Lisa Blatt. Only Lisa Blatt can do Lisa Blatt. You cannot do Lisa Blatt. And I thought it was worth reading a few sections of why you can't do Lisa Blatt. So Justice Jackson asked this long, I guess I'm trying to understand why it's atextual in your view to focus on this idea of use of a mark as a source identifier. Because it seems to me that what you're describing as the problem is courts grappling with the degree of expressiveness of various items in terms of determining whether or not this art exception should apply. And her question goes on from there. And it ends with, what's wrong with that? Blatt. Well, unfortunately, a lot. And with respect, literally, you're taking language in the text of parody, in the text of the statute, which you had a Supreme Court case on. Designation of a source are actually exceptions under 2 statutory provisions that don't appear in infringement. So I'm fine with you just making stuff up. So Justice Jackson, I think, pretty gently pushes back. No, but I'm not making stuff up. I mean, you said this other thing. Blatt interrupts and says, confusion has nothing to do with designation of source. So no, you're just sorry, but in trademark law, you can have a very confusing use of trademark that's not. Now Justice Jackson interrupts her. This gets kind of heated, David, and I'll tell you, as I was listening to it live, I felt very awkward. And then you've got an interesting back and forth with Alito. I'm sorry, Adam, let me find this. And then you've got this very interesting back and forth with Alito, where he's basically saying, how could there be confusion of whether Jack Daniels made this dog toy? It's clearly like, why would the CEO of Jack Daniels ever agree to make a dog toy that talks about number 2 on your carpet? Clearly, people are going to know that Jack Daniels didn't make this. Therefore, these exceptions don't apply. So they get into this back and forth. And Blatt says Nationwide ran a Super Bowl commercial with a dead child in it, and they had to pull it because it was such a bad idea. I don't know who approved that one. It was really embarrassing for them. People make dumb commercials. And Blatt continuing, I think if you're selling urine, you're probably going to win on emotion. And Justice Alito has to interrupt because he's not saying like literally they're selling urine. They have this back and forth. Uh, he's trying to clarify. She's interrupting. And she says, okay, my bad. And she says, well, just showing how confused I was suggests that I would be your perfect consumer. That gets laughter. Again, you are not supposed to be the one getting laughter as an advocate. That's considered a no-no. And after the laughter subsides, she continues, Justice Alito, I don't know how old you are, but you went to law school. You're very smart. You're analytical. You have hindsight bias. And maybe you know something. He interrupts and says, well, I went to a law school where I didn't learn anything. And she says, it's just a little rich for people who are at your level to say that you know what the average purchasing public thinks about all kinds of female products that you don't know anything about, or dog toys that you might not know anything about. And he interrupts and says,
Wow.
I don't know. I had a dog. I know something about dog toys. Again, all of this, the whole argument, frankly, is things Lisa Blatt can say that you can't. There are cases, I thought Angry Cheerleader was one of them, where I think that there is a great reason why clients want to hire Lisa Blatt, because she can say things and do things that other advocates can't at the court. But man, some of this was, well, she was the spiciest justice that day.
Yeah, that is some pretty remarkable stuff to hear that. And in reading it, you think, I really hope people were smiling during some of this. It
And
reminds me of when
they clearly were.
Yes. And it reminds me though, Sarah, do you remember when we had, was it McKay Coppins from The Atlantic on, and you and him were going at it?
Yes.
And I said, I just want you to know that they're still smiling at each other.
Yes. Yeah, that was so funny. It was such a good example of where body language and familiarity mean that there's certain conversations where you have all this subtext that you're aware of with your colloquitur. But the audience has no idea, and mommy and daddy are fighting. Like, no, mommy and daddy are having a great time.